Hello, Dave Clark here. Matt and I just recently handled a large accident case causing the death of our client. In Michigan, that is called a wrongful death claim. Under Michigan law, the decedent, the person who gets killed, has a right to collect money damages for their conscious pain and suffering and for any damages for the loss of income and support of their loved ones. In this particular case, a large trucking company pulled out in front of our client and unfortunately killed her almost instantaneously. She didn't have a seatbelt on, or at least the evidence appeared to show that she didn't have a seatbelt on at the time of the accident. Because the death was caused instantaneously, the defendant, this case the large trucking company, claimed, well, there you can't collect damages for pain and suffering because, quite frankly, unfortunately, there was none. In this particular case, our client was 60 years old, retired, wasn't making any money, didn't have a husband, and her children were all gone. They'd all left the house. And so the defendant argued, well, the decedent doesn't really support anyone. She wasn't earning any income. So what really are the damages that you are intending to prove in this case? Again, under Michigan law, you have a right to bring an action for what is called loss of consortium. Loss of consortium means that, for lack of a better word, the loss of the society and companionship that the person who died provided to her blood heir relatives. In this particular case, we could demonstrate that our client had a significant and very strong relationship with her family. She had raised these kids of her own, had a long time standing relationship with her brothers and sisters, and especially later in her life, she became very important to the grandchildren in this case. She took care of some children that unfortunately had birth defects, and they became very attached to Grandma. And Grandma became very attached to all the children, because when she was taking care of the special needs children, she obviously was taking care of the other grandchildren too. Again, we still had the hurdles of no conscious pain and suffering. There was the issue of no seatbelt, and she obviously, unfortunately, did not provide monetary sustenance to her children and grandchildren, brothers and sisters, but she was very beloved, very beloved. We proceeded to go to arbitration in this matter, not arbitration, facilitation. And it was our position that even though there was no conscious pain and suffering, even though you might deduct some money for the failure to have her seatbelt on, under Michigan law, that's 5% deduction. Even though she had not supported the children financially for years, that her extraordinary relationship with her children, her grandchildren, her brothers, and her sisters, she was literally the glue of this very large extended family. We were able to get one of the largest settlements over in Eaton County. It was $4.75 million. It was done at facilitation, where our clients, although could have chosen to go to trial, and we've been more than willing to go to trial for them for this special case, they decided that this was a reasonable settlement, and we proceeded to go ahead and settle the case and distribute the money to the living heirs.